This conference will now be recorded.
All right, well, welcome everyone. Welcome everyone to the Seidel Law Office's Estate and Business Planning Review course. This webinar is exclusively for the Seidel Law Office clients. So if you are attending this webinar this evening, that means that at some point in time you used our offices for some estate and business planning documents. We're so happy to have you with us tonight. I guarantee you're going to get a lot out of this webinar. The purpose of this webinar is to help you decide if it's going to be in the best interest of you and your family to schedule a review meeting with us to determine if you should have your documents updated. So we're going to learn about a lot of things tonight that would prompt your needing to update your documents. Jim Seidel and I will be making this presentation tonight. My name is Sonia Restisi. I am an associate paralegal with the Seidel Law Offices. Attorney Seidel is joining me tonight with this presentation. He's going to be monitoring the slides. So a reminder to Jim that you'll need to move those slides forward. We're also joined by one of our real estate paralegal who's with us tonight, Ron Smallwood. So we'll go ahead and get started.
Okay. So let me just add to that. I certainly appreciate everybody showing up. We got really nice response to our email and to our email blast. And I feel like I'm surrounded by family members here. Got many people. I recognize all your names, and I want you to know you have blood all over your documents. That's how hard we work when we do these documents, and we want to make sure your documents work, that you know why they're working, and if you need to update them, we want you to know we're standing by to help you. Let's see here. There we go. Okay, just a little bit reminder about myself. I'm a second generation attorney. My dad started the law practice in 1941. I've been an attorney since 1980, former judge advocate. I concentrate in business and planning. I still do that. I have something like around 1,300 clients, and I have a Juris Doctor degree, Master's of Law and Taxation from William & Mary, licensed in Virginia, DC, U.S. Tax Court, Maryland, U.S. Supreme Court. I'm a member of the National Network of Estate Planning Attorneys. Most of you will have red binders, and that's the mark of the National Network documents. There's about 350 law firms. Many of you probably don't recall this, but we have, last 10 years, we formed our own limited liability company in Indiana, and we have a mainframe that keeps up-to-date documents every month. We get updates. So you can imagine if you, we did your plan 10 years ago, we have done 10 times 12, we've done 120 updates to the documents since we've done your documents. So that's the National Network is really excellent. I think, as far as I'm concerned, the best in the country, keeping on top of changes to documents. Right now, by the way, if we do someone who hasn't seen us for, say, 10 years, changes to the documents can encompass like 30 pages of additional changes, which is why we want to keep you up to date on what's going on. Roving practice and my bio, page 6 of the introductory booklet. When you got the email blast announcing this webinar, attached to that was the workbook, which is referred to here as the introductory workbook. And so that's there for your perusal at your leisure. Now, joining me as she's already introduced you, is Sonia Restisi. Sonia is a remarkable lady. She has been around a long time, and she is just graduated from the, tell me, Sonia, Thomas Jefferson Law Reader Program?
That's right, yes.
Okay. And that makes her eligible to take the bar exam, which she is scheduled to do next February. And so I will have a younger and prettier person involved in helping the law firm. And Ron Smallwood, Ron is kind of on the opposite end. He hung up his license to practice some time ago, but is helping us out. He brings an immense amount of wisdom. He is on the, at least in my screen, he's in the upper right-hand corner of the screen. I'm in the left-hand corner. Don't let the fact that I have less hair bother you. I'm still wiser than ever. So back to Sonia. She's a former paralegal with various lawyers until she finally came and worked with the best guy. She was in the National Bank in Fredericksburg, and these are some of her. She's now full-time with me, and she brings a lot, again, an incredible amount of information, experience, and a wealth of knowledge to the firm. I have enlarged my office and staff. These are 6 offices that I now have. I don't see Manassas on there. So we now also have an office in Manassas. I now have 5 paralegals. They're listed here. 2 of my 5 paralegals are joining us in this presentation tonight. So I'm going to turn it back to Sonia. Sonia is going to do the presentation. I'm going to provide color commentary, and Sonia will probably repeat this, but at the end, we're going to have a 30-minute session for questions and answers. And I think we're going to keep everybody muted till then, and then we'll let you answer questions. You can also ask questions by way of the chat. And while Sonia's doing the presentation, I'll do my best to either respond to those chat questions, or we'll use the 30 minutes to answer those questions.
Right.
Okay, so I guess let me take this slide, Sonia. So there are handouts available pursuant to our ongoing dedication to our prior clients. Introductory booklet, which I mentioned earlier. If you want to get an updated version of that, it was attached to your email, but you can always contact our office to get it again. Copy of today's slides will be available. Recording of today's webinar, and this is being recorded. Evaluation and sign-up form, and a 50% discount certificate on your fees.
I think you meant to say 5% discount, Jim, but.
What did I say?
I think you said 50%.
No, not quite. Okay, 5%. Thank you. All right, Sonia, take her away.
Okay, so like I said at the very beginning of the webinar, the purpose of this webinar is just to inform you of some recent changes and not so recent changes in the law that could probably impact your current estate plan documents. So we're going to show some of those things on this slide 1. Federal and estate tax law changes. For the past 13 years, there has been some major changes in federal and estate tax law. We've got some slides, upcoming slides, so that we can show those to you here in a moment. Jim, if you want to go ahead and list these. So yeah, the rising cost in nursing home, assisted living, home healthcare costs. I've got some pretty interesting graphs to show you about that. That impacts your estate plan, and we're going to find out why here in a moment. Another federal law, HIPAA, the HIPAA laws that are meant to protect our information from getting into the hands of the wrong people. Well, that law has really wreaked havoc on estate planning documents. Nowadays, your documents have to pre-waive your right to HIPAA to allow your fiduciaries to access that information. So that's got to be in your documents. Virginia statutes have changed. They've changed their code sections. So it's a good idea. It's probably a good idea to go ahead and make sure that your documents have the current statutory citations. And then the new motor vehicle provisions, especially here in Virginia, when you go to the DMV and you want to put your automobile in the trust, these days they're wanting to see that language in the trust that says that these vehicles are being used for personal use. Okay, otherwise they're going to want to charge you business taxes on your cars. And we don't want that. So we've added the language that they like to see. So that should be in your documents. The next slide has,
So I want to say something about the federal and state estate tax law. This is huge for those of you who sought our services, say, maybe more than 10 years ago, because the major changes occurred at both the state and federal level. Virginia, for example, has done away with federal estate taxes, and the federal amount that you can exempt before you're taxed at the federal level has gone to 11.4 million. It changes a little bit because of its index to inflation. What that means to you is that for those of you who did your documents before these estate tax laws went into effect, major changes may be needed to your documents, or at least available to you to, if you want to either, in many cases, simplify your estate plan if that's what you want to do. Because when we did these before, when the exemption amount was around $1 million, we did some fairly sophisticated drafting to get around that $1 million. And a lot of that drafting, as good as it was, is no longer necessary. So I'm doing a client right now who we're doing away with the tax planning features of his trust, and that saves 20 pages in his documents.
yeah, that's exactly right, Jim. And so, yeah, we're going to see about that because Virginia got rid of its death tax in 2007. And so if your documents were done before 2007, it's likely you've got something called a family trust in your documents that has to be established when the first spouse dies. There's no need to have that any longer. It complicates your plan. It confuses your children and banks and financial institutions that look at this. And so, you know, and your estate plan should be simple, right? So that your family can administer it and understand it when these bad things happen to you. And so because of this drastic change in estate laws, we can simplify your plan now, and that would be best for you and your family. It's like COVID-19, that's not really a change in laws, but we have found that because of this terrible plague, your end of life decisions, your medical directives are being scrutinized even more than ever before. And I've had a lot of clients come in and they'll adjust their medical directive, and they may have their daughter as their ordinary healthcare power of attorney, but they may want their daughter and their son to serve as co-end of life agents. So we have a second pair of eyes looking at that end of life decisions. So that's something that has come about. Funeral directives, I put this on the slide because this is something new in Virginia law. Now, Virginia law has a statute that says that you can decide who's going to make all of your funeral arrangements. Okay, you need a document that says who you want to make the funeral arrangements. It doesn't have to be your next of kin anymore. You get to decide. Now, that document does have to be witnessed and notarized. So that's an additional document we're offering to our clients. What's the next one on this list, Jim?
John, here, gotcha.
Okay. All right, yeah, the Secure Act of 2019. Now, this is a very recent law, major change to retirement plans. Okay, this has never ever happened before. The government has decided now that the retirement plans, the taxes have to be paid within 10 years for non-spouse beneficiaries. And this has greatly impacted your documents. So this is something you want to make sure that your documents have the stretch out provisions allowed by the IRS, so that your trust, for example, can receive a retirement plan due to these change in laws. We're going to talk about more about all of this here in the upcoming slides. The Tax Cut and Jobs Act of 2018, what that did was that doubled the estate tax exemption. Okay, so as we talked before, that estate tax, the federal death tax, has been rising, slowly rising over the past 13 years. We're going to see a graph here in a minute that the estate tax 13 years ago was around $675,000 was all that you could pass before you get hit with that 45% rate. So that 2018 tax law doubled the estate tax exemption, And here again, as Jim said, you may have something in your living trust called a family trust, or maybe you even have that embedded in your will. There's no need to have that any longer, you see. You don't need to complicate your estate plan. And the problem with these family trusts, they have to be established. They have to be created, they have to be established. If it's there, it has to be done. So you might want to get rid of that, so it's going to simplify things for your family and anybody looking at these documents.
Yeah, I want to say something about the retirement plan change. That was a significant change. One of the criticisms of living trust was that they were not very flexible when it came to retirement plans. And what this new act did is it put living trust on a better par with all other, say, a will plan or no plan at all. And so it made it a lot, basically it leveled the playing field for living trust, which was a good thing. Another thing I should mention here is that some years ago, I want to say maybe 5 years ago, the United States Supreme Court said that when retirement plans are held in a trust at the death of the retirement plan owner, that those retirement plans are protected from bankruptcy. So that was a huge plus for living trust. That was a U.S. Supreme Court decision that said that retirement plans that are kept in a living trust have protections from bankruptcy, whereas if they're not in the trust, they may be subjected to forced distributions from the bankruptcy court.
That's right. So on this next slide, we're going to look at changes in best practices. Okay, so a lot has changed over the years with regard to estate planning documents. You know, we've become a lot wiser and smarter, and know more about what needs to be in these documents to protect you and your children. Trust protector provisions. So we're starting to add the trust protector provisions. What that is if because of your incapacitation or your death, you can't amend your document any longer, but due to maybe a change in law, your document is not working as effectively as it should. If you have the trust protector provision in your document, then you don't have to worry about that, because your trustee or the beneficiaries can appoint someone, maybe an attorney or CPA, to be the trust protector, and the trust protector can amend the document in order to make it work properly in that circumstance. So that's something else that has come down through the pike for estate plan.
So somebody just chatted that we want to make sure we're not leaving out our Maryland clients. I have a lot of Maryland clients, and so I just want to mention one thing I forgot to say about Maryland. The Maryland estate tax is still in effect, though. Last I looked, it was like a $5 million exemption. So Maryland has a little trickier situation for protecting estate taxes, and we may want to, especially with Maryland married couple clients, we may want to maintain what we've traditionally called the marital and the family trust to double the amount we can protect from estate taxes in Maryland.
Yeah, that's right. Not every state has gotten rid of death taxes. There's a few handful of states in the country that still have a death tax. So depending upon where you're residing, you know, we got to keep that in mind. Asset protection trusts for children have become very, very popular. I mean, even for your adult, healthy, responsible children, you know, you're not worried about your child wasting away his inheritance, but you might be worried about the people around him, such as a divorcing spouse or creditors of bankruptcy. So putting your child's inheritance in an asset protection trust, naming your child the trustee and naming your child the beneficiary, where he can access it whenever he needs. His creditors can't take it. So this is something, and we're going to be looking more at another slide that talks about some other various beneficiary sub-trusts, but this is one example of something that's been a new development. Managing fiduciaries, okay? You know, so we're now adding language to your documents that would allow one co-fiduciary to be able to handle the everyday ordinary task. So for example, if you want both of your children to serve as your disability trustees, so co-disability trustees, taking care of you when you're incapacitated, that's fine. And we can manage the tasks between them and make it less burdensome on them by putting language, making one of them the managing disability trustee to handle all those everyday ordinary tasks, but they're both involved in the decisions. No contest clauses. Contest clauses are very important in your estate plan, okay? This prevents a disgruntled beneficiary from wreaking havoc on your documents, on your trustee. So we want to make sure that we have all of the powers available to us by law, and the Virginia statutes have changed this language. So we want to make sure that we've updated that so that we don't have to. Your trustee doesn't have to worry about a disgruntled beneficiary pulling him into court for something that's not authorized by the trust.
So I just want a little bragging thing here. Of my 1,300 or so trusts I have done, not one has ever been penetrated by legal action. There's been a few with the consent of the beneficiaries. They have gone to court over maybe some unclear matters that aren't clear with them, but no one has successfully contested any of our trusts. So that's a kind of a bragging thing to throw in there.
Right. So we're also adding this limited power to vest, and Jim and I were talking about this today, and this is really important because this allows your trustee to keep distributions within the trust. So your trustee has a decision whether to make a distribution to your beneficiary, possibly your children, and so we wouldn't want those distributions to be taxed at a trust tax rate, which is a higher tax rate. So this language allows the trustee to have those distributions kept in trust, but taxed at the beneficiary's tax rate, which is always much lower. Something new that has developed.
So for instance, let's suppose that we don't want to make a distribution to a child that, say, has a chronic drug problem or alcohol problem, or is just in a bad situation. We traditionally, if you did not give that child his income, then that was taxed, his or her income, that was taxed at like about a 37% rate, which is very high. Whereas if it had been distributed to the child, it would have been taxed at, say, maybe a 16, 17%. So you'd be saving 20% by making the income distributions to the child. But you don't want to make those distributions because the child is, again, has a drug problem, or there's some other reason. Maybe there's a divorce going on or bankruptcy going on. So this limited power to vest allows you to retain the income generated by the beneficiary's trust without having to pay the 37% tax. Huge benefit. It was also one of the things that sometimes people were critical of living trust, and we've closed yet another loophole to make the trust work much better.
Yes, that's right. So these are all examples of things that have just happened recently, within the past 10 years or so, that this could greatly improve your documents, and we just wanted to bring your attention to these things. The limited power to appoint, just a little bit of a technical thing, but here, what this does, it allows your beneficiary to redirect his inheritance if you wanted them to redirect their inheritance, should they die before they receive all of their inheritance. And here, if you want to limit where they can redirect it to, like limit it, they can only give it to their kids, right? Not to their spouse. So that's a new development that we could add to your documents. We certainly talked to you about that.
Okay.
So again, as I said, Virginia got rid of its death tax in 2007. At that time, the Virginia death tax rate was $2 million. That's all that you could pass to your loved ones. Every dollar above the $2 million was taxed at the Virginia tax rate. That was repealed in 2007. So if your documents were done pre-2007, it's likely that you have that you have some provisions in your documents that you no longer need, like family trust or subtrust that have to be created upon the first spouse's death. So there's really no need to have those provisions in your documents, and it just confuses your loved ones and your beneficiaries and banks and financial institutions.
Yeah, once again, for you Maryland folks, there is a little bit bigger challenge in Maryland with only a 5 million exemption. That by the way, that's a moving target. But we'll work with you on that. And yeah, so I just want to point that out to.
That's a good point, Jim. That's good. Changes in the federal state taxes. So I have a really nice diagram here. The next slide over. Jim's in charge of the slides. So here you can see that the death taxes, the federal death tax exemption rate back in 2000, it was $675,000 was all that the federal government would allow you to pass. Every dollar above that was taxed at that dreaded 45% rate. Well, that has increased now. See down here in 2020 now, look how much that's increased. We're now at $11 million. A person can pass up to $11 million death tax free, federal death tax free. So because of that, you know, there are a lot of provisions and language in your documents you no longer need. And it might be beneficial for you to come in and have those provisions removed just to kind of simplify things for your family.
I'm getting there. This drawing tool worked for a while, but okay, here we go.
Okay, so now we're going to get down to the nuts and bolts of this course, guys. A general overview of your estate planning. You are all clients of our office, so you've heard all of this before, but I think it's really important for you to remember why you did estate planning in the first place, right? So we have a really nice definition here, and it covers both parts of the estate plan. I always tell my clients there are two parts to estate planning, the before death and the after death. You have to have both parts covered. Jim is having a problem with the slides. Okay, there, Jim. That's what I want the folks to see here is the first part of estate planning before death is you want to be able to control things when you become incapacitated. You want to be able to name the people who's going to be managing your money, your income, your assets, you and your family, your medical care. That's the before death planning. Your estate plan documents should cover that. So you don't have to worry about the government getting involved. 2, you want to be able to control what happens after you die. Okay? And so you get to decide who's going to be in charge of things when you're gone. And then you get to decide where your money is going to go, where your assets are going to go, and how those assets are going to be distributed. So that's that after death plan. And so both sides have to be covered. And of course, you want to save every last tax dollar, professional fee, and court cost possible. I mean, with a good estate plan, you put the power and control with your family, your loved ones, and you don't need to have the courts get involved or even a professional. I really like this diagram because it says that we have the before death plan and the after death plan. Okay, and tonight you're going to remember who you've named, you know, to be in charge of these things before you die and after you die. So it's important that you know that covers both sides. So your estate plan, your estate reviewed. I meet a lot of people and they tell me, well, Sonia, I don't have very many assets or income. You know, I don't have a whole lot, so I don't need an estate plan. And they are very wrong. I mean, they couldn't be farther from the truth there. Because what they have is they have themselves, you see. They have their body. You know, who's going to be taking care of you when you become disabled? I mean, you know, you need to have a document in place that says who you want to be taking care of you and managing your income and all of that. Because if you don't have that, then the government has to come in and do that. And that's called conservatorships and guardianships. And those are for people who don't have a plan in place. And there's a lot of people that don't have plans in place. So that's why the government has to come in and do that for them. So you've got yourself, you've got your spouse, your descendants, and other loved ones, and all of those people need to be taken care of before you die. And then assets, of course, if you have assets, then those assets have to be managed, and you want to have, your plan should name someone to manage all of your assets. So these are just some examples of what type of assets you might have. You are an existing client, so you've gotten some documents from us. So you might fall into one of these. Now, living trust package, or you might have a traditional will package. We're going to look into more about what that involves in a moment. A business entity, maybe you started a business, and so you came to us to register your business and create all your business documents. Or we might have done a document a la carte. You might have come and asked for a financial power of attorney for your 18-year-old son. I get that a lot. I have clients coming to me and they want their son to sign a financial power of attorney because now he's an adult, and if he becomes incapacitated, the government will step in and manage his assets. So a la carte, you might have asked for a special needs trust for a disabled child. Okay, so the next slide shows the two primary estate plan packages that we offer. And so you're going to recall which one you fall into, the living trust package or the will package. The next slide has an example of what we might have given to you. So if you've done documents within the past 10, 15 years, we would have given you two sets of originals of your documents, one set of originals in a red binder, like one that's on the screen, and another set of originals in the gray envelope. And this is important. We do give you two sets of originals in case you lose one set. You need to have original legal documents. We're not at a point in our society or our government that will allow copies of legal documents. Legal documents have to be in original form. So when we do have a meeting with you and we review your documents, we're going to want you to bring that red binder and gray envelope to the meeting, because we're going to make sure that all your documents are still in proper order. I can't tell you how many people I've met with where they're missing documents. They're missing their documents and they can't be located. The red binder also has a tab for listing the assets of the trust, listing your household items to be distributed upon your death, and other things. So the next couple of slides, we're going to review your living trust. All right, so for those of you who have a living trust, pay particular attention to this. Now, remember that there are 5 general advantages for using a living trust, and I had already mentioned a couple of them before. A living trust is going to cover both sides of the estate plan, before death and after death. Before death, because you've named a disability trustee to be able to manage those assets when you become disabled. Okay, so that's your before death. And then that avoids the government conservatorship. And after death, you've named someone to distribute those assets to your loved ones after you die. And that avoids the government probate. Living trusts avoid all probate before and after death. So we're going to see that living trust just is controlled by your family and your loved ones and never has to go through the court process. Because a living trust never has to go through the court process, you can improve the way that you leave your estate to your beneficiaries. You can get very creative and very complex because the court doesn't get involved in the management of any of that. Unlike a will, you can do a sub-trust under a will too for your loved ones, but you don't want to get too complex or creative because the government is managing that, and they get kind of confused as to what that's all about. That just kind of holds up the process. So a living trust does simplify things because it keeps it within the family, and it gives all the control within the family. Now, just a reminder of the living trust, as we see in this green box. A living trust just holds your personal estate during your lifetime. You are the grantor, you are the beneficiary, and you are the trustee. So you are in control of all of your assets. I like to say that the living trust is just a mirror image of you. It's just your alter ego. So it doesn't change the way that you own, operate, or control your assets. These are still your assets. The big benefits are when you become disabled, you've named someone to manage those assets. When you die, you've named someone to manage those assets and avoid any government control. This is a diagram of a joint living trust. So years ago, we didn't do joint trusts. 15, 20 years ago, they were unheard of. That's because the laws just weren't adept to handle a joint trust, and lawyers didn't know how to do a joint trust. So 15 years ago, a couple would each have to prepare their own trust. Wife would have a separate trust, husband would have a separate trust, and it just doubled the administration problems. But these days, you can do a joint trust, and in most situations, not all, most situations, husband and wife can do a joint trust, and it just simplifies things for them and for their family. They don't have to separate all the assets into two separate trusts any longer. They can keep all the assets all titled to one trust, the joint trust.
So some of you may have separate married trusts, and that's going to be applicable in some cases. So don't panic if you have a separate, if you're married and your husband has a trust and your wife has a trust. That's probably fine, but that's something we'd probably want to take a look at. We have, I'd say the last year, we have consolidated maybe a half a dozen separate married trust into a joint living trust. It really does make things work more efficiently, and you only have one set of documents to worry about when you do a joint trust.
That's right. And so as we see from the green box and the pink box, what this is this provides creditor protections on these assets when the first spouse dies. Okay, and that's really important. And I mean, you don't have to have these boxes added to your document, but you know, you might want them. What they're going to do is when the first spouse dies, a portion of the assets is going to be protected from the surviving spouse's creditors. We're going to talk a little
Those
bit
of
more
you
about
who have a family in a marital trust, we might have done it in the past primarily to protect you from estate taxes, because this little arrangement with a family in a marital trust doubles the amount you can protect from federal estate taxes. So when you come back for a review and you have a family in a marital trust, one of the things we'll look at is, do you want to continue to do that? By doing away with it, you greatly simplify your living trust, but you also lose some critical creditor protection protections, such as nursing home lawsuits and that kind of thing. So we're going to have to weigh the pros and cons. Some clients say, let's go ahead and get rid of the family marital trust. Some will say, no, let's keep it in. So those are things that we would discuss in the living trust. Note the blue boxes at the bottom there, child 1, child 2, child 3. So we're going to also discuss whether or not the various subtrusts that we've established for your children, assuming we've done that, are the right subtrust for your child. And we're very good at this. There's about 6 or 7 different subtrusts that can be created for children or other beneficiaries. And we want to take a good look at that to make sure that it makes sense. For example, let's suppose you had a minor child when we originally did the documents, and now that minor child is way beyond the age of majority. Well, we might want to switch that from a minor's trust to an adult general needs trust or an adult convenience trust and that sort of thing. Or maybe we've had cases where we had a special needs child that has that we've decided that he or she's functioning okay, and we no longer need the special needs trust, which is a highly restrictive trust, and we don't necessarily want to have it if we don't have to. So
yeah,
these are the things that we want you to be thinking about when you think about your estate plan, and things that we'll be working with you if you come back for a review.
Yeah, that's right. So you might have an old trust that has both the family trust and the marital trust. And because of the change in the tax laws, you don't need that green box anymore, and that just complicates things. But see, that pink box, you still might want that, because that pink box is going to save a portion of the assets from going to the surviving spouse's creditors, which could be nursing homes, bankruptcy, things of that nature. if you have a disabled child, you probably want to preserve a portion of the assets for that child rather than going to the nursing home of your surviving spouse. So these are some things that we're going to take a look at when we hone in onto the specifics of your plan to decide if you need to remove some of these things. So let's review your traditional will. So there are some of you out there that have a traditional will plan. And keeping in mind that the will has to go through the government probate. Okay, that's still the case. Unfortunately, it hasn't changed. This is a diagram of a husband and wife couple using wills. And typically, not always, but typically, husband's will names wife as beneficiary and wife's will names husband as beneficiary. And then the contingent beneficiary is their children or other beneficiaries. So we see this. The reason is on that. Oh, did we? Yeah. The reason why we do it this way is we set it up this way is because there's probably no need to probate both of these wills. Probate is expensive and burdensome. So in most cases, only one of these wills is going to be probated, and that's going to be the surviving spouse. Okay, so if you keep your assets jointly titled, and keep spouse as beneficiary on all of your assets, then all those assets should flow automatically to the surviving spouse, and there's only one will that would be probated. The will is very important because you get to decide who's going to be managing everything. That's the executor. You get to decide who your guardians are going to be for your children. So if you've had more children, or if you've had children since you've done your documents, or if you've had a child that's become disabled, it's really important to update your will because your will is going to name who you want to serve as guardians for those disabled minor children.
Yeah, let me just say something that just occurred to me. Make sure that if you want to make changes to your documents, whichever document you want to make a change to, don't make the change on the document. Don't pen and ink that change on the document. That could potentially revoke the document. What you want to do is make a copy of the page that you want to change, make the change on that copy, and then get us involved, and we'll help you formalize that change that you want to make. So if you want to remove a trustee or executor, don't just simply cross out that person's name on the document. We could have some serious legal problems. Instead, copy that page, cross out the person you want to be removed. This is just an example, and then forward that to us, and then we'll advise you how best to do that. That's kind of a side note there.
Yeah. These are just some important review questions. Do you have all your necessary documents? As I said before, you want to make sure you haven't lost any documents. So you want to make sure all your documents are in order, or maybe you've missed something that you need. Are your documents still valid? Are the people that you've chosen to handle these various roles, do you still want them to be handling these things? So are your fiduciaries still accurate? Are your beneficiaries still accurate? So these are things that we're going to look at. We're going to look in your documents and refresh your memory as to who you've named and who your beneficiaries are and how they inherit. Are your beneficiaries' inheritance protected? This has become very, very, very important these days. To make sure your beneficiary's inheritance is protected is just a little bit of language to add to the document, but it's just hugely important. Changes to your beneficiaries. Do you have a beneficiary that's passed away or become disabled or gone through a divorce or has significant debt? Or do you want to inherit a beneficiary? So these are some typical questions with regard to your beneficiaries. Now, if you've remarried or if you're worried about creditors attacking your estate after you die and you're married, then you and your spouse can add the marital trust. So on one of those prior screens, that's what I talked about. You might already have a marital trust in your documents, and you just want to get rid of the family trust because you don't need that because the state tax laws changed, but maybe you want to keep the marital trust. We want to look at that marital trust and make sure it's exactly the way that you still want it Do you still want your wife to be the trustee when you pass? Do you still want her to have complete access over it? And what's to happen when she dies? So where should it go? But the marital trust is going to be protected from her future creditors, for example, nursing homes and those types of creditors, and remarriages too, if she should get remarried. Jim, did you want to go back to that prior slide? Because there were some things. Inheritance protection trust, we talked about this for adult responsible children. You know, you're not worried about your child being irresponsible with his inheritance, but maybe the people around him. Divorcing spouses, bankruptcy, student loans are become a real issue these days. Common trust. So typically common trusts have been used for multiple small children to allow unequal access for their general needs. But Jim and I do a lot of common trust to hold, say, the beach house. You want the beach house preserved for your children, and you want them to be able to enjoy it when you're gone. So we can put your beach house into what we call a common trust, or maybe you want your family farm to be put into trust so that your family can continue to enjoy that. We may also talk about maybe doing a dynasty trust for the family farm, but the common trust has evolved to include these other things. General needs trusts are typically for underage children. You know, you certainly don't want to leave a sizable inheritance to an 18-year-old. It's not going to last long if you did. So you put it into a general needs trust. The trustee can distribute the assets for the 18-year-old's general needs and for college, things like that. And then you get to decide when you want your child to have control over it. We recommend that it continue in trust, in a convenience trust for your child, but you decide when he's 30, do you want him to become the trustee of his own inheritance trust, or what age will he have control over it? Lifetime trusts are going to be for those waywardly beneficiaries. You know, you got a kid that just cannot save a buck or a dime, right? And is never going to have nothing. And you put his inheritance into a lifetime trust, so he has some type of security there for him for the rest of his life. Or if you have beneficiaries that have addiction problems. Special needs trust requires special language so that the government creditors cannot take this from a special needs child. So we'll talk, Jim has a special needs child, as we can see here. You might have remembered that Jimmy, Jim's son, is a special needs kid, and he's a lot older now. I think he's about 22, 23 years old. And there Jim is with his son. They're standing in front of their yacht. Also, changes to your specific gifting. This is really important because you might have like a special gift in your document. One thing to note about the special gifts, they have to come off the top. So, you know, if you have a special gift, $10,000 to each and every of my then living nieces and nephews, and 20 years ago you had one niece or nephew, and now you have 20. Okay, so now just think about that. These come off the top before anything goes to your primary beneficiaries. So if you've got special gifts, we want to take a look at that and see if that's still something that you want to keep in your documents, or you may want to adjust them. Remote heirs. So the remote heir, I always say it's highly unlikely the remote heir is going to get anything from your estate. But if all of your primary beneficiaries and all their descendants are dead, then the remote heir inherits. Probably not a problem for big families, but you know, if it's just you and your kid and you might have one grandchild, then it's just 3 of you, right? So if you all should die in a tragic accident, then your remote heir gets everything. So that in cases like that, it becomes important. Changes to your fiduciaries. Okay, so this is important. Who have you named to serve in these various roles? For your traditional will package, you're also going to have those before death planning documents, the documents that say who's going to be managing your money, your income, and your assets, and your medical care. The financial power of attorney is the document you've named who you want to manage your money, your income, your assets when you become disabled, before you die. The medical power of attorney is where you've named the person to make all your medical decisions for you when you can't communicate to the doctor anymore yourself. And this is where you've named that person to make your end of life decision. So these days we can split that role up in two parts. You can have someone making your everyday medical decisions and then have somebody else perhaps making your end of life decision. Your executor of your will, of course, we talked about that. Who is going to be settling your estate through the probate process? That's the executor. Your will might have created a trust for your child. Okay, so that will would name a testamentary trustee, the trustee who's managing that trust for your child. That's going to be found in your will. And then the will also have who you want to serve as guardians of your minor or disabled children.
Yeah, let me interject here. We're going to try to wrap this up in a little bit here, Sonia. But I see a couple people leaving. So just want to remind you that we're offering a follow-on session here, and to people that would like to do that. And the best way to do that, Sonia, join in with me, I think, is to contact Linda.
Yes. We're going to see a slide here in a moment that says we encourage you to sign up for a review meeting, and that's where we're going to look at the specific details of your plan. That meeting is 2-hour-long meeting. We do charge a very small nominal fee, $300 for that 2-hour meeting because we have to pay our staff. But we think it's very, very beneficial to you, especially if you haven't had, looked at your documents in a very long time. Your documents definitely need to be reviewed. You need to know what you've done in these documents, and that's what we will go over all of that with you. So even if you decide that you don't want to spend any more money to make any changes to your documents, at least what you're going to get from that review meeting is we're going to tell you exactly how your documents are going to work. Traditional will package, as I said, we have the before death planning documents. That's the financial power of attorney and the medical power of attorney. And then after you die, the after death planning document is the will. So we have both sides of the planning process covered here.
Yeah, so one of the things, of course, when we review your documents is we'll look at these various fiduciaries, the executors, guardians, trusts, and trustees to see if they're still the ones, people you want. We've also added a new appointment of temporary guardians because we found out that a number of our clients have young children, but the guardian they want appointed is maybe in a foreign country, and so there has to be a period of time where someone else will maybe take care of the child while the final or the full-time guardian is able to arrive on the scene and take custody of the children.
Yeah, that's right. So just a reminder to everybody that the will does require the government probate supervision over the will. Probate is a legal court process. The average time to get a will through probate is about 1.5 years. And I know this because for 12 years, that's all I did was help executors and administrators through the will process in Virginia, DC, and Maryland. So it's going to take about 1.5 years, and that's because the government's not going to want the executor or not let the executor make any distributions until the court is satisfied that all of your creditors have been satisfied, and the IRS is a big creditor, so it takes at least 1 year to figure that out. About 10% of your estate and probate tax, all the assets that go through the will have to be taxed. And so the probate tax is a percentage of the assets that go through the will. So I have a lot of clients that start off with a will because they don't have a whole lot of assets and they need the will in place to appoint guardians for their children. But as life goes on and they start accumulating a lot of assets, then they quickly switch to a living trust because they don't want to have the probate tax on those assets. Hey, Jim.
Okay.
Go ahead.
Yeah, so this is Henry W. Apps wrote a bestseller on living trust. Henry and I were friends. I invited him out a few times here to Virginia. He was from the West Coast. And I put one of the pages here to his book called The Living Trust. I say it's a bestseller. And the point that Henry was trying to make here is probate is something that generally you want to avoid. And this is sort of the mess you get into when you get into the probate process. And remember, your wills are taking you through this. You're way ahead of the game if you have something in writing versus nothing at all, but you're not nearly as far ahead of the game as if you have a living trust in place.
That's right. Living trust package. Again, as I said before, the living trust covers the before death, the after death. So your living trust will name a disability trustee, the person you want to be managing everything when you become disabled. Typically in a married couple situation, you're naming your spouse as your disability trustee, but then you've got to name someone as a backup to spouse because your spouse eventually is not going to be there. Death trustee, the living trust will name the death trustee. It's synonymous to executor. The difference between the death trustee and the executor is the death trustee doesn't have to go through probate, avoids all of that, can settle your living trust in the privacy of his or her own home. So there's no filing. The document is not filed with any government court body. It's handled in the privacy of your children's home. Even if you do a living trust, you're still going to have a financial power of attorney because we can't put all of your assets into a living trust. For example, we can't make the living trust the owner of your Medicare card, right? So we can't make the living trust the owner of your tax return. So when you become disabled, when your disability trustee, who's also going to be named as your attorney in fact under your financial power of attorney, will be handling those non-trust related type things. Medical power of attorney, you'll still have that, naming who you want to make your medical decisions for you, which, by the way, all these documents have backup fiduciaries. So you might have named the first person you like the most to be able to handle this, but you do need to have a strong backup. I always recommend you have 3 people named, just in case those first 2 people can't do it. You've got a solid 3rd person named. Of course, the pour over will. We provide the pour over will if you fail to put an asset into your living trust before you die. You just forgot to put the RV, the title of the RV, into your trust. Then that motor vehicle is subject to probate, and your pour over will would have to be filed with the court, and your RV would be probated. And of course, the will names who your guardians are going to be. So this is an idea of the documents involved with your living trust package. Here's a nice little diagram of a before death planning in the living trust. As you can see here, all of your assets are placed into the living trust. The purple box is your assets. They're moved into the yellow box, the living trust, before you become disabled. And then when you become disabled, you see here that you've named someone to be able to manage those assets for you. That person is going to be the same person that you've named under the financial power of attorney. We see that arrow going up to the financial power of attorney and the medical power of attorney. So typically we have the same person managing all of your money, your income, your assets, and your health care, just to kind of make it easier for the situation. The next diagram has your after death planning. Okay, so after you die, you've named somebody in the document to serve as your death trustee. The death trustee, it could have been the same person as your disability trustee, or it doesn't have to be. And here, that death trustee, in the privacy of his own home, will settle your estate and do all the things that an executor would do, but without any government supervision. And then your trustee will distribute those assets to your children in those little blue box. And a lot of times that death trustee will continue to manage the children's inheritance until that child reaches a certain age. Okay. So just a very quick review on what's going to happen when your spouse dies. All right. We have a lot of questions. What's going to happen when my spouse dies if I have a living trust? So here, this is a diagram of a joint living trust. A couple with a joint living trust, and then the one spouse dies. Okay, so the document provides that the deceased spouse share of the assets will funnel into that blue box. So we have a sub-trust established upon the first spouse's death to hold the first spouse's share of the assets. This is really important. If your spouse has already died, you know, and you haven't done this, then you definitely need to meet with us to determine if we're going to do this or not. Because if you've got this blue box in your documents, and then and you don't fund that, you don't do what you're supposed to do when the first spouse dies, then there could be problems down the road. Jim, do you have anything to elaborate on that? No.
No, I think you got it covered. Thanks, Sonia.
Also, if you've gotten divorced since we've seen you last, I'm sorry about that. That does happen. Or if you've gotten remarried or married, it's likely that your assets have been already settled between you by the court. But one thing that you might have missed, which you need to do this, you need to notify your divorcing spouse that he or she has been revoked on all the documents. This is extremely important. So we prepare formal notifications to that ex-spouse. And then what you need to do is you need to prepare new documents, naming somebody else other than your spouse. If you decide to get remarried, or if you're already remarried, if I was going to meet with you, I would talk to you about a marital agreement. Okay, these are sometimes known as prenupts or postnupts. But a marital agreement is going to protect your assets in the event that you get another divorce or if you die. And it's best for both of you. It helps her, it helps you. So that we do marital agreements all the time, so we can certainly help you with that. Another thing, do you want your new spouse to be your fiduciary? Do you want your new spouse to be managing all your money when you become incapacitated? Do you want your new spouse to make your medical decisions? So we'll talk to you about that. What do you want to do about the children from prior marriages? When you die, do you want your assets to continue to go to your children from your prior marriage? Or do you want your assets to be put in a special trust to support your second wife until she dies? What are you going to do about the joint assets? Okay, so I've had a lot of this lately. His trust, her trust. Now we've got joint assets. We're buying a house together. We're opening up a joint bank account. So a lot of times we will advise them to prepare a joint trust to hold those after acquired joint assets. And then, we're talking about a marital trust. So perhaps in that joint trust, and when the first spouse dies, everything still stays in the trust to support the surviving spouse, but we have some creditor protections on that joint trust from the surviving spouse's creditors. If you get married to a non-citizen, this is something that we need to talk to you about. We need to put some provisions in your documents. Otherwise, your estate could be subject to the death tax. Non-citizens are not exempt from the death tax. Jim?
Okay.
Disability and extended care cost. So here's what we're going to see a problem with we're going to talk about the rising cost of healthcare in a moment. You're going to see some really interesting graphs on that. But my question to you is, have you or your spouse become mentally disabled since we last saw you? Has one of you entered into a nursing home? This is important. Now, if you've named your disabled spouse as your fiduciary, then you need to come in and have your documents updated. We can't have your incapacitated spouse being named as your fiduciary. Here, if you think that there's going to be a serious illness between you or your spouse, if dementia or Alzheimer's runs in your family, and you've already see signs on the wall of your cognitive issues, there might be a way that we can protect your estate from being completely exhausted by the nursing home cost. Okay, you have to pre-plan for this, though. I mean, you can't do it on the night before you move into a nursing home. All right, so you see here that there is a 5-year period. A 5-year period has to lapse to make this work effectively. You transfer your assets to an irrevocable trust, and then 5 years after that transfer, those assets cannot be taken by your nursing homes.
So probably half a dozen times each year, we will actually do one of these irrevocable trusts for people who have onset dementia, or in some cases, both spouses have that problem. And what we're trying to do is protect the estate from nursing home and extended care facilities.
That's right. That's exactly right. Okay, rising cost of healthcare. We know that those costs are going up. This was a graph that I got from Genworth Insurance Company, and it shows that the private nursing home costs from 2004 to 2019 have drastically increased. So we see this is the annual cost for a private nursing home. 2004 looked like it was roughly $65,000 per year. Now we know it's on average $102,000. So these are average costs. So these costs are going up, and we're going to have to figure out a way to pay for these things, right? Assisted living facility has also gone up. Looks like it's gone up by about 30,000 since 2004 for that. So these graphs, I really wanted to put these graphs in here so you can see that these costs are rising. I know that you already knew that, but these were interesting graphs. Here, in-home care costs have also gone up for your home health aides. We know that those are very, very expensive to bring someone in the home for that. Okay, so one of the things we always talk about when you come in for a review meeting, we always make sure that your plan is properly funded. Depending on if you have a will or a trust, it's going to be handled differently. So funding of your will, and if you have a will, your will is going to be funded differently depending upon if you're married or if you're single. If you're married, it's likely that all your assets will be held jointly during your lifetime. So a lot of times, typically I'll tell couples who are using wills, keep all your assets joint during your lifetime so that when the first of you dies, all those assets will automatically pass to the surviving spouse. Single people, you keep your assets in your sole name during your lifetime. Life insurance policies, retirement plan accounts. If you're using a will, then you'll want to name your estate as the beneficiary of your life insurance and your retirement plan accounts. Now, that's not going to be the same for everybody. Not everybody will handle it that way. That's why we want to meet with you individually to find out what's going to be best for you and your circumstances. Jim.
Okay. I was handling a chat question.
Right. Funding of your living trust. You need to make sure all of your assets are in your trust, preferably before you become disabled, absolutely before you die. Your assets have to be in your trust. Your house has to be deeded to your trust. Your bank accounts, your trust has to be the registered owner of your bank accounts and your investment accounts. The trust has to be the beneficiary of your life insurance policies. The trust has to be the beneficiary of your retirement plans. If you're married, your spouse is the first beneficiary, and the trust is the contingent beneficiary. If you're a single person, the trust is the primary beneficiary of those retirement plans. And that's what we call a properly funded trust. So that's one of the first things I always look at when I talk to people. Let's make sure all your assets are properly in the trust. A lot of times, if it's been a while since you've seen us, we'll ask these questions. Have you acquired new real property? Because it's likely that you didn't get that deed transferred to your trust. Okay, so we can certainly prepare a deed for you, making sure that new acquired property is in your trust, especially if you own property outside of Virginia. Okay, so if you bought a mountain home in Colorado, you definitely want to put that into your trust, because if you don't, you're going to have the mountain home's going to have to go through Colorado probate. And that's going to be burdensome and costly on your children to do that. Have you changed your bank accounts? Did you have a falling out with your banker and change a bank account? And did you make sure that you register that new bank account to your trust? Have you purchased a new automobile? I bet you have. Did you make sure that you put those titles in your trust? Life insurance policies. Have you rolled over your retirement plans through multiple employers? We want to make sure that your trust is still the beneficiary of the retirement plans. Started a new business. It's really important for businesses that you assign your business to the trust, so that when you become disabled and when you die, your trustee won't continue to manage that business interest without the government involved. Received an inheritance. there's a lot of things to talk about with that. So the next slide, Jim.
Okay.
This is just kind of a nice example of putting your assets into your trust. For real property, automobiles, and bank accounts, your trust is the owner. For life insurance policies, your trust is the beneficiary. And for retirement plan accounts, if you're married, your spouse is the primary beneficiary and the trust is the contingent beneficiary. Okay, you'll be able to get a copy of these slides after tonight's webinar to look back at that. The importance of funding your trust so that those assets are going to be managed by your trustee. So if the asset is not in the trust, your trustee can't manage that asset. So we want to make sure that now if you die, if you fail to put an asset into your trust and then you die, that asset will have to go through probate, the whole probate process we just showed you, but you have a pour over will that says after that asset makes its way through probate, your pour over will says that your trust is the beneficiary. So eventually that asset will make its way back to your trust. Business planning, we do have a lot of clients with businesses, and so we highly recommend those clients register their business with the State Corporation Commission. Jim, do you have that next slide?
Yeah, so let me take these slides here. So we do a fair amount of business planning every year. These are some of the reasons why we do a business planning for you. If you have any kind of business activity going on, we urge you to, if you don't have it organized or incorporated, please contact us. We're gonna help you get the protections you need from the business because businesses can spawn all kinds of disputes, lawsuits, and that kind of thing. And we will, our entity of choice is limited liability companies. We do them in Maryland, we do them in Virginia, we do them in DC. Some of the business entities are here. And again, we generally focus on a limited liability company. Just the last client I had today, we did this very thing. So, and this gives you simply the inside outside protections of limited liability companies so that if you are sued within the LLC, it can't get to your personal estate. And if you are sued from without the LLC, they can't get into the LLC itself. So, okay, Sonia, back to you.
Yes, we're almost at the end of these slides here, and we'll open up the floor for questions very soon. But these are some other things that might have happened. We already talked about the divorce or remarriage, or if you've had children since you've last seen us, or if you've had grandchildren since you've last seen us. We want to talk about make sure those grandchildren are provided for. Have you moved and have you made substantial gifts? There might be some gift tax implications that you're not aware of. So we want to talk to you about that. And have you received an inheritance? And inheritance are important because maybe you want to provide some special protection on that inheritance to kind of keep it in the family, things like that. To receive a recording of today's webinar, so in a few days, I think it's like 2 or 3 days, we're going to have this webinar saved on our website. Okay, so you'd just have to go to the website. At the bottom of the welcome page, you'll be able to see a link, and that link will connect you to our YouTube channel, which will have a copy of today's recording. Also, you'll be able to call the office. So Linda Palmer, the receptionist, will answer your call. And Jim, I think the next slide, we're going to tell folks tonight that they can get you can get a copy of this recording emailed directly to you. And that's going to be available a lot quicker than the website. I believe we'll have that available within the next day or two, and Linda will email you a copy of the recording. She'll also send you a copy of these slides. That might be kind of nice because I know we went through them rather quickly and there was a lot of very good information on these slides. So she'll send you a copy of the slides. This is Linda. She's the secretary or receptionist. She's very, very sweet. She's very nice. If you want to schedule a review meeting with one of our paralegals or lawyers, I highly encourage that you do. Like I said, I feel like if it's a nominal fee to meet with us, about $300. We do have to pay our staff. You get 2 hours meeting. We ask you to bring your red binder and your gray envelope because we're going to make sure that all your documents are in order and make sure that everything's properly funded. So you're gonna receive well worth your time there. The best way to contact the office is by calling us or emailing us. So here's our telephone number. You might make a note of that and the email address, and you can ask for a copy of all of these handouts by calling the office or emailing us. So yeah, so contact, if you want to schedule a meeting, like I said, the best way to do that is call the office or email the office. We have some offices that are available for us to physically meet with you. However, during this COVID-19 virus, we're handling a lot of meetings by virtual meeting, such as like tonight's webinar, the GoToMeeting feature. It's proven to be pretty successful, but we'll still meet with you in person. If you really want to meet with us in person, we will meet with you in person. Please ask you to call Linda, because Linda will tell you which offices we are meeting in person and which offices we're not. Trying to keep everybody safe here. So I think now, Jim, that we can open the floor up to anybody who has any questions.
Okay, let me try to unmute to see if I got this figured out here. Okay, so any questions? And again, you can ask them in verbally or in the chat.
Jim, I have a question.
Okay.
You mentioned retirement or various vehicles that could go into the living trust as the second person who would inherit in the living trust, be the spouse first. So does that include pensions? Do pensions just go to the spouse only? That's different for other retirement.
Yeah, it does. There is a different analysis for pension. So your pension check generally will go into a bank account, and it's probably, if it's going to be taxed, it's taxed in the year that it's distributed. And it's important that bank account that receives that pension check, this is true with Social Security, by the way, that account be named in your living trust, so that if you're disabled, you can continue to receive that pension check, and the people managing your affairs when you're disabled can take care of it. So hopefully that answered the question.
Yeah, now I understand. When you die, they're not going to get anything unless it's the wife that inherits it, of course.
That's right. It's really the pensions.
But when you're disabled, you can at least get it to manage. Okay, I understand now. Thanks.
Okay.
Yeah.
Good to see you guys, by the way.
You too.
Jim, I have a question.
Okay.
Jean must.
Hi, Jean.
Hi, how are you?
Good.
My question is, recently you did a review earlier this year for my new husband and I.
Okay.
He was working with his own attorney, and then they set up a deed for the current home that we live in, which was Pat's home, and added me. My name is on there, it's just my full name. Should that have been my living trust, the name of my living trust? Is my question clear?
So the other lawyer did the deed, is that what you said?
Yes, the other lawyer here in Maryland did the deed, and he was working on Pat's behalf. It was his attorney.
Yeah, I remember this. So did you do you own the property together? Is that the idea?
Yes, now we do. He's 2/3 and I'm 1/3.
Yeah, so one way we might have handled that, or I might have recommended we handle that is, if let's say you're remarried and you bring a piece of real estate into the marriage, or you acquire property, generally, or one way approach is 1/2 of the property goes in your living trust and the other half goes in his living trust, or if he doesn't have a living trust, just in his own name. I don't know if that answers your question, but I would like to see that. I would like to take a look at that deed.
All right, I'll send that deed to you tomorrow.
Yeah, just yeah, and we'll take a quick look at it.
Yeah, I'm concerned about that now. Okay,
Yeah.
thank
Another way that you could handle that, Jean, and this obviously you want to talk to Jim or someone in our office about it, but you and your spouse might consider creating a joint trust. You hold.
I was thinking from your slides, I gathered that would be our best next step. Would the house go in that then? Is that what you're saying?
Yes.
Yeah. Yeah, so you would deed the house to the joint trust, and then your trust decides, how that house is held between the two of you. So the language of the trust would determine, because you had mentioned that, I think you said that you own 1/3 of it, or he owns 2/3. So
Yes,
it may be
right.
a complete split, but the joint trust could handle that. And then you'd
Right.
have the joint trust available to hold any additional after acquired joint assets that the two of you are likely to acquire.
Okay, yes. We just did a post-nup. Jim just did the post-nup for me, my half of it, I guess, and a review of the trust. And then he did Pat's attorney did the post-nup. So I guess is how it worked out. Isn't that how we did it, Jim? I think that.
Yeah, I think you're right.
Yeah, well, that's
Well, I think we better take another look at it. I'm not sure now that it's done properly. That, maybe we should do it a little different.
Yeah, let's take a look at that, Gene.
All right, I'll send you the deed tomorrow. Thank you. Thanks.
Okay, Gene.
You're welcome.
Any other questions? Well,
Jim, was there anything in the chats that you want to share?
I'm just looking at here the chats. Yeah, we have a question on retirement plans. Is the pension different? I think I addressed that. Does that have only one spouse as a beneficiary? Well, yeah, I think we addressed that. We talked about, anything. I think we tried to throw in as much of the Maryland information. We've, pretty much we've got the Maryland situation down cold. I mean, as far as the boilerplate goes. And so we addressed that from the chat room. I think that's all I could think of offhand that came from the chat. Well, I love seeing you guys.
Very helpful. Been very helpful. Thank you, Jim and Sonia.
Okay, great.
Thank you all for attending tonight, and we hope you take care and stay safe. And we are here for you. If you have any questions, you can always call the office and get your questions answered. It may mean we need to meet with you for a review meeting, but the point is we are here for you. We are still in business. We want to help answer your questions and help you with your estate planning needs. Thank you all for attending tonight, and we look forward to seeing you again sometime in the future.
Sonia, you want to tell them again if they want to have a review meeting, how they go about doing that?
Yeah, so just a reminder, if you want to have a review meeting with one of our staff, all you have to do is call our office. We have the telephone number here on the screen, or if you prefer, you can email the office. We've got the email address here, and someone from our office will call you. Probably Linda Palmer will call you. She manages all of our schedules. And she will schedule a meeting with you. She'll let you know which offices we're doing physical meetings in, or maybe we'll do a virtual meeting. It's whatever you're comfortable with. But that's the way to handle. If you want to request a meeting, please call the office or email us, and we'll get you scheduled.
And we'll actually stay here for a little while in case anybody wants to have a more intimate chat, should I say?
So Jim, do you want to go ahead and stop the recording so that we can go ahead and finish this webinar? The recording part. We can stay on.
Recording, but we're gonna hang on here for a bit.
Right.